Does it matter who files first in divorce? Hi, I'm Bill Farias, founder of Farias Family Law. We got this question last week. We met with this lady who is approaching divorce, and she wants to know if she needs to win the race of the courthouse. Should she file first? Is that going to help? First, there are circumstances under which it makes sense to file sooner rather than later. For example, let's say you are the high earner and you are looking at potentially having to pay alimony. Usually, the sooner you file, the better, because you are shortening the length of the marriage by filing sooner rather than later. If you're going to wait to file, then the marriage is longer and potentially your alimony obligation will be for a longer period of time. That's one example. Another example is if there is a property division issue and you are looking for some credit on premarital property. Generally, the way that it works is the longer the marriage, the more likely it is that a judge is going to consider property that the parties brought into the marriage, especially if there's no prenup. And so the point is, there are these very fact-specific and case-specific instances in which it makes sense to file right away. And that's something you need to talk to an attorney about as to whether it makes sense for you to do that. Once we put that aside, if you look at this issue sort of in a vacuum, then the only real advantage of filing first is really that you get to, or through your attorney, you get to present your case first at a pretrial hearing and at a trial. So typically, the plaintiff goes first. A pretrial is a very important hearing at which both sides make their respective presentations to the judge, and usually the parties get some feedback and use that feedback to try to resolve the case. And so if you're the plaintiff, if you filed first, you get to go first. And there is the issue of, or the principle of primacy. And basically the thought is that it's important for a person to hear your explanation or your presentation first, because then that anchors the person in your train of thought and your theory, and that person is more likely to listen to anything else that comes in from the other party through that lens that you basically created by going first and painting the picture for them. So that's a psychological principle. It's real. It's called primacy, and basically it says, hey, look, you want to be first because you want to tell your story first, because the person who is listening to you and making the ultimate decision is likely to be somewhat anchored to what you say and listen to what the other side says through that lens. However, there is also the principle of recency, which says that the last thing that a person hears, in this case a judge, is likely to have some influence also. So, and the reason for that is it's more likely to stick with them, right? They heard it last, and so they heard it more recently, and that might have an impact also. So when you weigh the two, I am a fan of primacy. I would rather go first. So again, this applies at both the pretrial and the trial. But other than that, there really is no real advantage to filing first. So if you file first, sometimes that actually makes sense as a matter of strategy, but you won't know whether that's the case until you talk to an attorney about your specific circumstances. And the other part of this is that you get to go first at these important hearings. If you have any other questions about this, you can call us 508-675-0464. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it. You can also email us at info@fariasfamilylaw.com, and you can find us on social media at Farias Family Law. Thank you. Have a good day.